separated away from the CMU. It hadn't come off yet, but it's going to.
Start tying it.
That was better than my 10 p.m. on Saturday staff report.
sorry, man.
Oh, it's all right.
You gotta do it when you can do it, you know?
Trying to
I was
just do
like,
the
wow,
right
that's
job
that's
until
pretty,
all this.
that's great.
Really.
I'm in for a shirt here. I'm just struggling to get here in the last couple of meetings. Fortunately, I kept canceling them.
Well, since you're the chair, I want to pull both your consent off.
I don't think I actually have any in the chair. Just FYI.
You don't want a mural down the street from your house?
Oh, I didn't see that one.
That's level 3. Peter Pan.
Yeah.
Whoosh. How's that?
Are you ready? Are we ready?
Mr. Park, go ahead and gavel us in there. This meeting of the Community Development Board is called to order on October 15, 2024 at 1 p.m. Welcome, everyone. I'd ask you to now please stand and rise for the Pledge of Allegiance. Pledge allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, welcome to the meeting. Thank you for coming today, and hopefully everyone got through the storm successfully with as little damage as possible. As you can see today, we are missing our chairperson and our vice chairperson. So under the city's code, the present members of the board will be required to select a member who is present to chair the meeting. Without influencing this process in any way, I strongly urge you to select Mr. Heinrichs just because it's his, he's been on the board before. This is his second go-round. So if one of you wish to make a motion to appoint someone as chair for the meeting, I'd appreciate that.
Second your motion? Yeah,
I can't make a
I'll make a
motion.
motion to appoint Mr. Heinrichs as the lead
we will all
dog today.
second.
I'll second that.
We have a motion and a second.
Thank you very much.
All those in favor?
Aye.
All those opposed, besides Mr. Heinrich?
Can I stay here?
Yes, with that, I will turn the meeting over to Mr. Heinrichs. I am here for you for whatever you need, but at this point, continue on with your script from where we left off.
All right. This meeting of the Community Development Board is called to order on Tuesday, October 15 at 1 o'clock. Welcome, everyone. We've already had the pledge.
Presenting at the gavel.
The board consists of 7 members and 1 alternate who are appointed by the City Council and serve voluntarily. I am Kurt Heinrichs, and I will ask the other members and the staff to introduce themselves, starting on my left.
Andrew Hupp.
Andy Park.
Aubrey Hotreport. Mike Mastersario.
Jay Danio, attorney for the board.
Rosemary Claus, City Clerk.
Matthew Midge, Assistant City Attorney.
Ted Kozak, Development Review Manager.
Lauren Mansky, Planning and Development.
Please remember to turn off your cell phones so that they do not become a distraction during the meeting. Please also refrain from having conversations in this room so that we might hear all of the testimony given today. To ensure a complete record of this board's actions, we ask that each individual wishing to speak, including the applicant, speak into the microphone at the podium in front of us. Clearly state your name, spell your last name for the clerk. Now I will ask all those in attendance today who plan to speak to rise and be sworn in by the clerk.
Raise your right hand. You affirm to tell the truth throughout your entire testimony. Yes.
Agendas of today's meeting are on the podium to your left near the entry door. Also on the podium are a roster of the Community Development Board, the list of the city staff experts and their resumes, the Board of Rules of Procedure, and the annual schedule for this board. The first order of business is to review and approve the minutes of last month's meeting. May I have a motion for the approval of the minutes?
I motion to approve the minutes of the last meeting.
Second.
I have a motion, I have a second. All those in favor? All those against? Motion carried. Items not heard on the agenda. Is there any person today wishing to address the board concerning any matter that does not appear on today's agenda? Seeing none, we will proceed to the consent agenda. This board has adopted a consent agenda format.
Mr. Hendricks, I'm going to interrupt you just a moment before you get there. You have a request for continuance on item E. It's probably best to handle that first before we get to the consent agenda.
Okay.
Just because it appears in the agenda before the consent
Okay,
agenda
request for
items.
continuance.
Yep.
Okay. We have a request for continuance. I'll read case number TA 2024-07002, amendments to the Community Development Code, Level 3 application. The applicant is the City of Clearwater Planning and Development Department. The request is to amendments to the Community Development Board to require a percentage of landscaping areas in the front yards of residential zone properties, clarify the use of organic mulch, establish regulations to allow the use of artificial turf citywide, limit the use of non-living landscape materials, update property maintenance standards, establish new, update existing, delete definitions, establish a fee for an artificial turf permit, and update section references. Associations are Clearwater Neighborhood Coalition, Board of County Commissioners, Pinellas County School Board, and the assigned planner is Jamie Lupko. Okay.
We understand staff is seeking continuance, is that correct?
Yes, we're seeking continuance. We would like to bring this forward to your next regularly scheduled meeting, which would be November 19th.
Okay.
All right. So if the board is amenable, we'd look for a motion to continue this item to the board's regular meeting, November
19th.
19, 2024.
I move to delay the amendments to the Community Development Code, case TA 2024-07002.
Second.
To the regular meeting, November 19, 2024.
To the regular meeting of November the 19th.
All those in favor?
Aye.
Those opposed? Motion carries.
Thank you.
Okay, now on to the consent agenda. The following cases are not contested by the applicant, staff, neighboring property owners, et cetera, and will be approved by a single vote at the beginning of this meeting. I will read each item on the consent agenda, and if any person wishes to remove this item on the consent agenda, please so state and raise your hand, and we will waive it from the consent agenda. All items removed from the consent agenda will be heard in the regular order of the meeting. Items that remain on the consent agenda will be approved with a single vote as to each type of hearing. Okay, I'll start with the level 2. Case number, then I read each one? Yeah.
Yep.
Case number FDL 2024-07017, 691 Harbor Island. Owner applicant is Brook Enterprises LLC. Representative Brian Unks Jr., McFarland, Ferguson, and McMullen, 625 Court Street, Clearwater, Florida. Location, east side of Harbor Island, approximately 650 feet north of Harbor Passage. Request for flexible development approval to construct 548 square foot dock, 95 feet in length, with 2 covered boat lifts as accessory to the detached dwelling use located in the low-medium-density residential Island Estates Neighborhood Conservation Overlay District for the property located at 691 Harbor Island. Request is for deviation of dock length and boat lift setback. Associations, Island Estates Civic Association, Clearwater Neighborhoods Coalition, Board of County Commissioners, Pinellas County School. Assigned planner, Melissa Huck Baker. Anyone wishing this item removed from consent?
I do.
We'd have one request to remove this item
Okay.
from the agenda.
All right.
Consent. Second level item 2 on the consent agenda, case number FLD 2023-05011, 685 and 689 Bay Esplanade. Owners Peter Pan Developments LLC and Peter Pan Development. Applicant Hoosh Gove, Northside Engineering, Inc., 300 South Belcher Road. Location, south corner of Bay Esplanade and Somerset Street. Request flexible development approval to construct 9-unit resort attached dwelling use in the tourist zoning district, Old Florida Character District of Beach by Design for properties located at 685 and 689 Bay Esplanade. The building will not exceed 50 feet for the first 60 linear feet south of Somerset Street, will not exceed a maximum height of 65 feet elsewhere, and 14 parking spaces are proposed. Requested is flexibility for height. Associations are the Clearwater Neighborhood Coalition, Board of County Commissioners, Pinellas County School Board. Assigned planner, Melissa Huck Baker. Anyone wanting to remove this item from the consent agenda this morning?
I do as well.
Okay. We have another request to remove this item from the consent agenda. Okay. The last item on the consent agenda is a Level 3 application, case number TA 2024-8003, murals and downtown window signage. Applicant is the City of Clearwater Planning and Development Department. Request amendments to the Community Development Code to clarify definitions for artwork and murals, and to modify window signage standards in downtown. Associations, Clearwater Neighborhood Coalition, Board of County Commissioners, Pinellas County School Board. Assigned planner, Lauren Maxey. Anybody wanting to remove this item from consent agenda? You'd like to remove it? Okay. So this item will also be removed from the consent agenda. In that case, we have nothing on the consent agenda, so we don't need to.
Let's go right to our procedures for level 2 cases.
We will now move on to the regular agenda. There are 2 types of cases that will be heard today, quasi-judicial and legislative. I will outline the procedures for each hearing at the beginning of the respective hearings. Procedures for the quasi-judicial hearing, level 2 cases. All level 2 cases, such as flexible development, are considered quasi-judicial hearings. In a quasi-judicial hearing, the Community Development Board reviews the application, the staff report, correspondence, and all evidence presented today, and makes a final decision subject to appeal. The board has previously qualified all city staff who will testify as experts in their area of professional training, education, and experience. The list of city staff experts and their resumes are in the handbook on the podium near the entry door. Any other professionals who wish to be qualified as expert witnesses shall request at the beginning of this case to present a resume to each board member. The board shall determine whether or not to qualify that person as an expert in what field of study. At the beginning of each level 2 case, I will ask for anyone who wishes to request party status to come forward and state your reasons. Party status may be granted if the person requesting such status demonstrates that he is a substantially affected person. The board will then determine whether or not to grant party status. Then the case will proceed as follows. Request for party status. Request for party status. Presentation by planning, and Development staff, 10 minutes. Presentation by the applicant, 10 minutes. Presentation by persons with party status, 5 minutes. Cross-examination of the witnesses by the Planning and Development staff, cross-examination of witnesses by the applicant, cross-examination of witnesses by persons with party status. Followed by that, we'll have comments by the public, 3 minutes per person. Closing remarks by the Planning and Development staff, 3 minutes. Closing remarks by persons granted party status, 3 minutes, and closing remarks by the applicant, 3 minutes. Closing of the public hearing and discussion and a vote by the board. Okay. Our first level 2 case today is, we'll start with,
Yeah, you've already read these, so we'll start with number 1, FLD 2024-07017 at 691 Harbor Island. I'd also like to advise the applicants today actually for all 3 items today, that you have less than a full board present, and you do have the right to continue these items to the next regularly scheduled meeting because we are less than 7 members today. I also wish to advise that this board cannot approve anything with less than 4 members voting affirmatively. So there are 5 members here today. A 3-2 vote simply results in a moving to the next meeting of the agenda item. Items cannot be approved on a 3-2 vote. It needs to be 4 in the affirmative. So in as much as that informs your decision, please let us know now if you wish to continue your item to the next regular meeting date. Anybody wish to do that? Okay. Mr. Chair, then seeing none, we should proceed with request for party status on our first application, FLD 2024-07017.
Jay, I think he was.
And you are, sir?
Matt Temprin,
I'm sorry?
Temprin, T-E-M-P-R-I-N-E, it was for the joining the 9 townhomes.
Okay, that's Peter Pan Developments LLC. That's item number FLD 2023-05011. Applicant has indicated a desire to continue his application as of right to the next meeting. Is that correct? Okay, we will do that. All right, let me ask you to come up to the microphone and say it. I want our record to be clear here today. Come on up.
Good afternoon, Bushko Wahi, Northside Engineering. We would love to stay on the agenda today if that's possible. I apologize for a misunderstanding. I should have communicated with people. So we'd like
We just
to
want to make
stay
sure you're aware of the right. We got it. So we'll go back now. Thank you very much,
Yes,
Mr.
thank
Gouvet.
you.
We'll go back now to the first item and seek requests for party status.
okay. Okay, we'll start out with case number TA 2024-07002, amendments to the Community Development Code.
Nope, that's your continued item on level 3.
I'm sorry.
That's okay.
That's continued, and then we have 2. Hold. Okay. Okay. Request number FLD 2024-07017, 691 Harper Island. Owner applicant, Brook Enterprises LLC, representative Brian Ungst, McFarland, Ferguson, and McMullen. Location, east side of Harbor Island, approximately 650 feet north of Harbor Passage. Request, flexible development approval to construct 548 square foot dock, 95 feet in length, with 2 covered boat lifts as accessory to the detached dwelling use located in low, medium-density residential / Island Estates Neighborhood Conservation Overlay District for the property located at 691 Harbor Island. Request is a deviation of dock length and boat lift setback. Associations, Island Estates Civic Association, Clearwater Neighborhoods, a coalition, Board of County Commissioners, and Pinellas County School Board. Assigned planner, Melissa Huckbaker. Does any board member wish to disclose any ex parte communication on this case? Is there anyone in the audience who wishes to request party status in this case? All right, so I guess we will start with a presentation by city staff.
Mr. Chair, at this time, I would ask that the board accept Ms. Melissa Hawk Baker as an expert witness in general planning, zoning, redevelopment planning, land development code amendments, special area plans and overlay districts, site plan review, landscape architecture, historic preservation, comprehensive sign programs, and all other matters she is about to testify hereon.
I move to approve Melissa Hawk Baker.
Second.
All those in favor?
Aye.
All those not in favor? Approved.
Good afternoon. My name is Melissa Held Baker. This is case FLD 2024-07017 for the property at 691 Harbor Island. The request is for a proposed dock for a single-family home, and the property currently has a single-family dwelling under construction. And prior to that, the property was vacant since 2008. The location is one parcel. It is 80 feet of waterfront length and approximately a 1,000-foot waterway. It's on the east side of Harbor Island, 650 feet north of Harbor Passage. It's within the Island Estates Neighborhood Conservation Overlay District. The zoning district is low-medium density residential, which permits as a primary use single-family dwellings, which our code calls a detached dwelling, so that is what is under construction. So the correct use is going at the proper location. The surrounding land uses are all the same, and they are all predominantly single-family dwellings, with most of them have docks. Specifically, when Island Estates was created in the late 60s, as it has individual fingers for each street, the idea was that it would help to promote the utilization of the waterways and allow homeowners to have a private dock. The property has been surveyed by Quest Ecology, and the image on the screen is showing the result of their survey. There are seagrass beds that extend the entire length of the property and extend out from the seawall approximately 60 feet. So that presents a construction dilemma in that you are not supposed to disturb environmentally sensitive areas. Which leads to the proposed dock layout, which features the following compliant items under the code, which is CDC section 3-601, subsection C1, small letter A and small letter C through F. And this is for specifically single-family properties that have a dock. The proposed dock will be 548 square feet in area. It features a 4-foot walkout. It's actually 4 feet by 81 feet. Which terminates at the dock head, which is 14 feet by 16 feet. It provides 2 slips, one on the north side and one on the south side, and each of the slips will feature a covered boat lift. The setbacks of the dock are 38 feet, and that would be on each of the property line. When you look at the side property lines as extended into the waterway, the walkout occurs at 38 feet, where the code requires 26.67 feet, or a minimum of 1/3 the waterfront, and then it's ultimately a minimum of 20 feet, so they exceed that. The setbacks for the boat lift on the north side are proposed at 20 feet, where the code requires 10 feet minimum. And that is under the same section area, 3-601, subsection C1A. The proposed width of the dock is 16 feet, where the code would allow for up to 28 feet in width. And that is equivalent to 35% of the waterfront property line. And the covered boat lifts with a permanent roof, which is what is proposed, are compliant and permitted under 3-601, subsection C, number 1, small d. So the level 2 deviation, which leads us to today's meeting, is under section 3-601, subsection C1G, III, sections A through D. And that is for the setback for the boat lift. On the south side is proposed at 5.6 feet, where the code would require a minimum of 10 feet. I would like to note that but for the length, if the seagrass didn't exist and the owner was allowed to shorten the length of the proposed project, there is a mechanism whereby it could have been approved as a level 1 administrative. You would have never seen it. And it is because each of the adjacent property owners have signed off and given their letter of no objection. So that, I think, is very important to mention, that each of the adjacent property owners find no objections with the proposed project. The proposed length is probably, the main issue that will be discussed today. The walkout is 4 feet by 81, and the dock head is 14 by 16, which ends up with a total length to the end of the dock head of 95 feet. The code would require, as by right, 40 feet length for a dock. So it's allowed half the waterfront distance, and that's under 3-601 C1B. 40 feet would put the entire project over the seagrass beds. Then additionally, as I had mentioned, administratively, level 1 would have permitted an additional 50% length of the dock, which would take it to 60 feet in length. And that only can be done if each of the adjacent neighbors sign off. And those signatures are notarized, so it is a legal document. And each of the neighbors have signed off, but the seagrass beds, as you can see on the graphic that's up on the screen, extend out to approximately 60 feet, which once again, that would put the entire proposed project over top of the seagrass beds. The resulting project is that the walkout must extend a minimum of 60 feet, and in order to accommodate the covered boat lifts, that is where you're seeing the slightly additional length to the walkout area, as well as where the boat lift covered roofs are positioned. It shall be noted that there's no official objection here by residents of the area. And it's also important to note that the harbor master has reviewed the project. He even went out in a boat and checked out the neighborhood waterway. and has deemed this project that there will be no navigational issues, and he provides his full support. Which leads me to questions.
Questions from the board?
I have a few, if I may.
Absolutely.
I'm just trying to understand, so every time we're up here, we seem to have a dock issue, and I need clarity relative to what the process is in the code, so I don't have this discussion every time, because I don't understand seagrass and how that's reviewed and applied
Right.
relative to the approval of these projects.
So I will allow the applicant and their specialists to discuss, exactly what seagrass beds mean. I am not a specialist in that area, but it is considered an environmentally sensitive area, which the dock code specifically addresses. That in order to seek deviation for a dock at a single-family property, the main first item is that the dock, let me read it for you. The deviation is a dock of lesser length poses a threat to the marine environment, natural resources, wetland habitats, or water quality. So it meets that criteria, and there are several others, and maybe some of the questions you might be having, and I'm not sure, could be that in the recent several months, we've had applications that were for docks, and they were for multi-unit properties. And the way our code is written for docks is it completely separates when you're seeking deviations for either a dock for a single family or a duplex property versus the multi-unit projects. So the items that we may have focused on in the other projects may not be as pertinent this time because it's a different use.
That's my question, because I have not seen a dock not permitted in a residential area in the past that has seagrass. And I know there's other processes and procedures to alleviate the lack of light that penetrates for the seagrass, whether it's decking or height, because I've encountered that myself on recent projects that I'm dealing with. And so how does staff approach those items? Because seagrass has never been an item for a residential dock that I've seen in the past.
So my experience in 11 years working for the city is that, we are not allowed to approve administratively, so at the staff level, a dock if it's going to be covering over seagrass beds. That is something that you need to, when I say you, that would be the property owner or the applicant, would need to have a licensed professional go out there, do the survey, get in the water, and document, exactly what are the existing conditions going on out there.
So surveys are required for all docks?
I don't know that I would say unequivocally that they're absolutely required, but if there's a question of why is a dock being designed in a certain manner, and that would be because of an environmentally sensitive resource, then we would want to have and see the benthic survey.
To answer the question then, had they not brought that forward to you, would you approve this dock if it met no deviations relative to the seagrass?
I'm not sure that staff would have felt comfortable bringing the application forward to you without having some of that other information.
I understand, but let's say I was building a dock at this current location within the code,
Right.
would they require a seagrass survey?
If there are no seagrasses documented and it's not mentioned to us, we wouldn't know about seagrasses.
So it's not required, is what you just said?
If the applicant would let's say hypothetically, not this property, let's talk about some other property. If an applicant were to submit an application, come in at the staff level, and we look at it, there's no mention of seagrass beds, it meets the length, it meets the width, it meets the setbacks, it meets everything, staff would then be charged with approving it based on how the code is written. What happens after that point, and when I say approve it, what we do is we put a stamp on the county application. We are one checkpoint on the county application process for the applicant. So then the applicant can actually physically take their county application over to the county and submit it. And then the county will literally dive into it, not to make a pun, but they do survey the site. They look at everything. And then sometimes what happens is it comes back to us. And sometimes it bounces back and forth. And these are things that never even have to come before the board because they still meet, they're still within the parameters of what the code provides.
So they need a county permit.
Absolutely. The county is the only issuing entity for Pinellas County for a dock or a boat lift.
Well, then the question arises then, every dock along Island Estates here doesn't have a length even half of this. And they were all approved and they all have seagrass. So I'm just completely.
All right. I don't know that I'm going to add any clarity here in terms of the questions that you're asking, but I'm going to ask the board to confine its analysis to this application. Understanding that there are questions about the process that can be.
Certainly. So relative to, let's say, all the other residential dock permits that were permitted along here, in this case, they don't deviate. They have a length of, let's say, 50 feet or less. I looked at every one of them. They all have seagrass, and they were able to get a permit from the county. So I just don't see this process being applied consistently, and I think that in this case, the deviation is like 50 feet, 55 feet longer than a normal dock in this whole corridor, and how is that not a navigational issue? Why aren't there conditions on lighting, signage, things of that nature? Because I've seen more jet skis run into a dock and get killed in all arenas, and I don't know if our marine manager is looking at those items and issues and just rubber stamping something like this. I think it's a safety hazard.
I think all of those items are actually, by the county, you have to have all of that information and provide all of those mechanisms. Because the county
why are
is
we
the
here
ultimate.
voting on this if it's a county issue? And
Because as she mentioned, look, we really need to stick with the application. You got two set of criteria here. You got the general standards, right? In 3-914, you have the standards that are applicable to this dock application. Beyond that, you have no power to do anything about it. We can lament about it, we can just ask questions about it, but you really need to confine your analysis to the evidence that you have in the record on this application. Processes, either past or future, are not before you today. They're just not. I recognize that
That's
there
fair
are
enough.
legitimate concerns about them, but they're not before you today.
that's fair enough. So I think clarity is what I'm looking for, is you defer to the county on all of the items that I'm asking about, but yet we don't have any answers to it relative to seagrass and the fact that, this is going to be 50 feet longer than everybody else in this corridor.
And maybe some of your questions could be answered by the applicant and their professionals. They've got, the folks who actually did the survey and, can provide maybe some insight to your questions.
Okay.
And
The
in
boat
this
lift
case-
setback, can you explain what that is? There's a deviation to that?
I'm sorry, what?
The boat lift setback.
Right, so in the code, under section 3-601, subsection C1A, is where it talks about what the setback shall be for a dock, for a single-family dwelling. And then it also includes in there a single sentence that says, boat lifts and catwalks must be setback a minimum of 10 feet. That's it. That's all it mentions. So this project is subject to that requirement of the 10-foot side setback to the boat lift. That is the
Okay.
one deviation that is
Thank you.
before you. The other deviation is the length, of course.
Could the dock not have been shortened to meet that setback?
I don't know how, what the boats are that are going to be, parked there. I know you don't actually park boats, but I'm not a boater, so.
Probably a better question for the applicant.
Yeah, I would say the applicant should be able to shed some more light on that.
Can I get clarity relative to the seagrass and how you, in the future, relative to how you guys view that and the consistency with the county, so that I can understand it and not pull this from the consent agenda as long as we
Right.
have clarity? Is what I'm
Would you be
looking
okay
for.
if that information we provide you like on a later date so we can have some time to just review our code and go through some
100%,
processes?
that'd be
Yeah.
great.
Instead of just trying to do it off the cuff.
Right, no, that's what I'm
Yeah.
asking for in the
Yeah.
future, correct, yes.
And I'll reach out to a contact that I have at the county, and maybe there is something that they have in terms of information and showing you everything that's required for a county application and so on and so forth.
It'd be helpful for the
Okay.
board to understand the nuances, I
Absolutely.
think.
And I'd just like to point out that Ms. Melissa Hawk Baker has provided two pieces of competent substantial evidence that you need to consider, which is the benthic survey and the advisement from our Marine and Aviation Director, who said that it doesn't impede navigational hazards of any kind.
And-
So,
Is someone here from the survey?
I couldn't hear
Mr.
you.
McDonald is not present.
Relative to your point, may I, if we can pull up the Google Earth image, is that possible here today? Of the current seagrass that exists there?
Well, yeah.
I'm gonna request that you not do that. All right.
Yeah,
So
would-
the applicant here and the city are permitted and required to, in some respects, present the evidence that they wish to show to the board. Okay, the board adducing evidence on its own is going beyond the scope of a quasi-judicial hearing, so I'm gonna ask that we not do that.
Okay.
And I think the applicant may have additional information that they'll be providing as well. Anything else?
Thank you.
Okay,
Thank
you're
you,
welcome.
Melissa.
Thank you.
Presentation by the applicant.
Good afternoon, Mr. Chairman and board members. Brian Ongst. Before I start my time, I'm going to hand out Al's resume, which you have all seen before, but it's required that I do this for the code. It specifically says I have to have a hard copy of his resume, and I have to give it to you at every hearing, and you have to look at it and vote to approve him, which is why I do it. So hopefully that provides clarity as to why I do this every single time, even though I know you guys don't need to see this again. But this is Al Carrier at PEPSM, and we're seeking to have him certified as an expert witness in all aspects of civil engineering, site design, permitting, including marina design, dock design, marina and dock permitting.
Any discussion as far as approval of Mr. Carrier as an expert witness?
I move to approve Mr. Carrier as an expert witness.
Second.
All those in favor?
Aye.
Opposed? Motion carries.
Thank you, Mr. Chair, and I do have a PowerPoint, if we could just pull that up quickly, and I will try to focus on Mr. Hupp's question specifically, so I'm going to skip through some of this. Just want to note, this is a vacant lot on Harbor Island, as Ms. Hawk-Baker said. The only other lot on Harbor Island on either side of the street that doesn't already have a dock or deck structure is also vacant. So this is one of two remaining lots on Harbor Island that do not currently have a deck or a dock structure. As you know, this is subject to the Island Estates Neighborhood Plan, the overlay. So it's an additional planning element that is an overlay specific to the Island Estates community that's over and above the Community Development Code. And as Ms. Hawk-Baker points out, Island Estates has been recognized since 2002 as having essentially two front yards, and water activity, including residents that are able to own boats and utilize boats, is encouraged, and dock structures and marina structures are encouraged in the community. The strengths of the community are waterfront homes, boating community, and all properties have access to the water and also allowed to have multiple boats on docks. So I'm going to get straight into the request. As Ms. Hawk-Baker said, there are two reasons we're here today. One is because the request is to permit the dock at 95 feet, which Mr. Carey will explain in detail why we have to do that. And the second is the deviation to the southern setback of 5.6 feet setback of the boat lift where 10 feet is required. Should be noted that neighbor has signed off a certified non-objection. She does not object. And as you can tell, there's no members of the public here today to object to the design or to the request. I will just add before Mr. Carrier gets up, I'm not sure about the other docks that were permitted, whether they were permitted prior to this version of the Community Development Code. But I can tell you when you have two regulatory schemes, you have the city of Clearwater who has dock guidelines, and you have Pinellas County Water and Nav who have dock guidelines, and then you have FDEP and you have Army Corps. Sometimes some of those regulations will change. So some of the things the city could sign off on in 2008, maybe they don't sign off on anymore because they know that something's changed with water and navigation, and that's something that Mr. Carrier is going to explain. But essentially, we don't want to do this twice. So we're at the first step, which is getting the city's approval. We don't want to get the city to approve something that we know the county won't approve. It doesn't make any sense to have to come back. And so I think Mr. Carey will be able to explain that. I can also tell you that in my personal experience, every dock or deck marina structure I have worked on in Clearwater since at least 2019, the staff has asked me to get a benthic survey. So that's been something that they've asked me to do, and we have done. And again, that may be because they knew that the county was going to require it and they didn't want it to have to come back. I will also say that I have had at least two docks, one that you just saw recently in Island Estates that had seagrass issues. And that seems to be, at least when my clients come through, that's the standard we're held to. So I'll let Mr. Carrier speak more specifically about the seagrass issue. And then Al, if you want to move forward to the additional slides, you can click on that.
You want to go back?
Yeah.
3 slides, because there was an aerial. Al Carrier, I'm with Trans Systems. We're located at 565 South Hercules Avenue in Clearwater. Last name Carrier. And I'll just address your questions regarding the seagrass issues. Because your process is so robust, we have to come before you for any project that deviates from the specific code. Once the project gets approved from you all, then we then have to take it to Pinellas County, where then they review it and approve it. The worst thing for us to happen is Pinellas County says you have seagrass or you have something coral or out there that you didn't identify in your presentation to the city of Clearwater, and we have to go back all through the process again, be heard before you, and then continue with the process. Quite frankly, that's a 3 or 4 month process every time you go through that. So in the last 4 or 5 years, like Brian had mentioned, we try and do all our due diligence up front. A benthic survey for this site is somewhere between $3,500 and $4,500. It's a lot of money for the client, but we feel it's necessary to get that upfront work done prior to moving this process along and going to the county. Same thing with bathymetric surveys. We did a bathymetric survey to ensure that we have proper depth wherever the boats are going to be sitting, because there's criteria from Pinellas County that requires a 1.5 foot depth of clearance between the bottom of the draft of the boat and any resources that may be there. So we try and get all that done beforehand. Years ago, residential docks were a lot simpler. They're now, because of the environmental impacts, they're being looked at more as a commercial dock or a multi-use dock. So they're continuing that same process. Pinellas County adopted or adopts the FDEP rules for environmental concerns, meaning if there's a possibility of no avoidance, meaning you're not going to put a dock over seagrass or coral heads, you have to avoid that at all costs. There's some areas in the city, for instance, along the bluff area, where you see the docks are out like 300 feet. A lot of those docks are over seagrass, but then they drop down to a next level of permitting criteria where you have to put grading, maybe for the whole length of the dock, and the dockhead has to have grading. They don't allow boat lifts over or roofs over the boat lifts to avoid shading of the seagrasses.
So Al, this shows the seagrass here, right, in the aerial?
Yes.
Okay, so I want to get to the technical drawings here, and I know we also have a seagrass demonstration here as well, so do you want to explain that?
Yeah, so we hired Quest Ecology to do the benthic survey. What we did is we took their mapping of the seagrasses, pulled it in AutoCAD, and you can see that it extends about 60 feet from the seawall. So knowing we're gonna have to go to the county, we want to provide complete avoidance of the seagrass. So we have to move the whole dock head structure and the roofs out from the footprint of the seagrass.
Can you
And then-
bring that
oh,
aerial
sorry,
back?
sure,
Can you
we're-
go back to the Google Earth aerial that you had before?
Yeah, we're still on our time, though. Do you want to wait to ask your question? or do you
Certainly,
want-
whatever you, yeah,
It's
that's
just,
fine.
it's up to you. We can
That's fine.
stop if you want, or, okay. All
That's
right, Al.
okay.
So this is an exhibit directly from the benthic survey provided by Quest, where they showed the mapping. Each of those little dots with circle with a hole in it is where they found actual seagrass, and then they mapped the outline of that seagrass. The seagrasses in Clearwater over the last probably 5 or 6 years have grown significantly because of water quality. The city's done great efforts to clean up the stormwater prior to discharge into the bay, and this is a result of it. You're getting seagrass beds that are starting to flourish again. You don't see this in all other municipalities, by the way. And so, again, going back to avoidance with the seagrasses in the structures.
And just real quick, I'll try to be quick here, but as Attorney Dano said, you have two sets of criteria that is under your purview. One is the general applicability criteria, which you're very familiar with, those 6 criteria. And the other is section 3-601.c.1.g sub 3, as Ms. Hawk-Baker pointed out. And the first provision of that specific section says, a dock of lesser length poses a threat to the marine environment, natural resources, wetland habitats, or water quality. And that's your specific criteria that relates to the seagrasses. And that may be why I was asked, starting back in 2019, to start getting benthic surveys for all of these projects that I've been working on in the city of Clearwater. And as you can tell from the staff report, the staff found that that was a legitimate issue. This benthic survey demonstrated that there were seagrasses that would be disturbed by a dock of a lesser length, or if the boat lift was in a different position, and that it's been designed as the minimum deviation necessary to avoid the impacts on the seagrasses and to allow for the reasonable use of the property. And that conclusion's on page 4 of the staff report. So basically it says the literal enforcement of the code would, based on the seagrass bed, would not be permitted. In other words, you couldn't site it any closer to the seagrass bed than we're currently siting it, thus rendering the waterfront property useless for dock development, which would be the only home in that neighborhood that doesn't have a dock. So we're being held to a different standard. I get it. And so I guess the answer is, if anybody out there wants to tear down their dock and redevelop it, they're going to be held to this same standard. And so the question then becomes, should the city council get involved and review the code? Should the county commission get involved and review the code? Are there statutory things that override the local jurisdiction's ability to impact seagrasses based on FDEP? All of those things are things that are really not before you today, but I understand why you would want to know why you're going to continue to see these types of applications, because you have seen quite a few of these applications over the last 4 or 5 years. Al, do you have anything to add before we conclude our 45 seconds?
Just one clarification. If you're seeing docks being rebuilt, if they're being rebuilt in the same footprint, the county does allow that. If they're surrounded by seagrasses, you're allowed to rebuild your dock in the same footprint, put the tide poles back in the same location. As long as you don't deviate from that, you're allowed to do that. So those may be some of the reasons why you're seeing other people build docks and not having to go through this entire process.
Okay, that concludes our presentation. We're happy to answer your questions, and we're on that aerial.
Sure. I just don't see the bump in the seagrass in that aerial, just for reference. It doesn't show up there, so I don't know why it doesn't depict it at this current time. Is that an old aerial? Is that something that?
That is an older aerial. I can't speak on behalf of what Quest has done. They actually dive it. They have masts that go out there. There could be sparse grass that they identified. In the report, I believe there's a chart of what they found and where. and I have a copy of it here. You're welcome to it.
You want it?
So I've seen it, yeah. The other question I would have is, why couldn't you have the slip parallel and not impact it on pushing it so far out? Why couldn't you turn your slip parallel to the seawall?
So we could, but then typically you'd only get one slip in that location instead of two. Residential docks are allowed to moor up to
Correct.
2 boats.
Right, and what about,
I'm sorry?
can you put tie poles and extend them further out? Let's say if you wanted to park your yacht beyond that?
So I believe one of the restrictions here from the harbor master was that no tie poles were going to be located further than what the dock is shown here.
Oh, I didn't see that. It was on the consent agenda. Maybe that was included in it. I don't know.
And I did have a conversation with him also regarding the length. He did go out in a vessel and drive it. What alleviated his concern, and I don't want to speak for him, but in the conversation we had, is the island tends to curve towards the west in that location, and the channel tends to run straight. So as the landmass pulls back, when you line up the docks, then it wasn't as aggressive as what it may look here on the plan.
Can you tell us the size of these boat lifts, the length?
The northerly boat lift is a 40,000 pound, the southerly is a 60,000 pound.
And what size boats do those hold?
So the lift to the north, they have a Pursuit OS, I'm going back, an OS 350, 305, which is a 36-foot boat or 35-foot boat. Then there's a pulpit, and then the engine, so.
Well, if you have a 40 or 60,000 pound lift, that'll hold a 50-foot, 60-foot boat. The sizing of that, I have a 36-foot heavy with triples, and it weighs 14 loaded. So you could put, I mean, I have a travel lift at my marina that, it does 20 tons, and it's nearly the size of these lifts with roofs on it. It's just, so the board recognizes it's enormous.
It can handle, yes.
It's
it can handle a larger
enormous.
roof,
This
yeah.
is the largest lift that you'll see in Pinellas County.
It should also be noted, just for the record, that boat lift size is not considered or before the board for consideration as it relates to the weight or any of those types of things, and the roofs are permitted. So the two requests are the 5.6 setback, which the neighbor approves of. She's the only one that's impacted by it. And the length, which the evidence has demonstrated the county requires to prevent impacts to the seagrasses. So again, we feel like we've met our burden of proof and the same standard that all of the recent applicants that you've seen have been held to.
Are the boats allowed to extend beyond the roofs?
They are allowed, but based on the information I was given, the roof line is to cover the boat.
So we'll agree to a condition that no tie pole will extend past, what was it that you said?
Extend past the outer limits of the boat lift.
I do have an email from the harbor master here on the tie pole issue. I just would like to read you a sentence about it if you all don't mind hearing it, so we're all clear with what he said. I can pass the email around you all too if you'd like to take a look at it.
Yeah, go ahead.
Sure.
It's the right way.
So we got the top here. My only stipulation would be that no tide pilings would be allowed past the end of the proposed roof structure to the east. Michael S. McDonald, PA, Director.
And is that included in this consent agenda item that you all had?
No, this is an additional condition of approval we would like to request,
Okay.
if you so choose to approve it.
And we agree.
Okay, great.
Any further questions
Yeah,
of
I
the
have a
applicant?
question about the setback. Was there some reason why you couldn't have shortened that 12-foot dimension to allow for a larger setback? Because I know that the neighbors have agreed to this, but the next guy may not.
I'm sorry, can you repeat the question?
So there's a 12-foot dimension you have from the dock to the end of the actual dock, the dock head, okay? And I was just wondering why that could not have been shortened enough to give you the setback that's required. It's another 7 feet.
So the current setback is 5.7 feet
Right,
To the
so if you
property
shorten the
line?
dimension, that 12-foot
to
dimension?
12.
It's 10 is what's required, not 12.
No, I understand, but I'm looking at the dock itself, so you shift the boat lift to the north.
Oh, so shorten the dock head,
Yeah,
narrow the dock head.
That would impact the seagrass over here.
Yeah,
well,
then-
that's debatable, but okay.
Yeah,
But-
if you look at, there's a bump in the seagrass. I don't know if we can put the PowerPoint back up. It's on the slide. So I think you're asking about the 12-foot dimension in between.
Yeah, it's very convenient the way, like he stated before, that how that takes goes in when you're looking at it. When I looked at the aerial, it did not look anything like that.
Yeah, well, I mean, trust me, if we
So-
had evidence to dispute this and we could make this thing less large and less expensive to build, we would do it. But we're provided the information from
Well, I'm just trying to think about the
scientists.
next person that buys property
Yeah.
to the south.
I guess they'll have the benefit of knowing what's there when they buy it, so.
I will say, if the county does go out there, when we go to county to permit, if the county comes back and says their benefit survey is wrong, and they want the footprint of the benefit survey reduced, we would certainly be willing to move the docks in. We wouldn't have to come before you, I believe, because it's a less
Less intense.
intense development. We would certainly be more than happy to do that. I'm sure the client would too, because it's less money to build the dock. 60-foot walkout over seagrass, it's a good walk when you're loading the boat.
Yeah. We would not want to have to do this if we didn't feel like we were being told we had to, so.
Further questions from the applicant?
Thank you.
Thank you. Comments by the public?
Don't forget your cross-examination, Mr. Chair. You've had your presentations by the parties. Your next item is cross-examination of witnesses by the planning staff or by the applicant as required, if they wish to.
Okay. Do we have anybody that wants to cross-examine?
City's good.
Did you call for public comment?
Not yet.
We called for it, but it was a bit premature.
Yeah.
Thank you.
It'll just be a moment.
You can stay if you want.
Mr. Johnson, you may want to stay right where you are. Mr. Runks, do you wish to cross-examine anyone on behalf of the city?
No, thank you.
Thank you.
What up, Bill?
There we go. Thank you.
Thank you. My name is Bill Jones, and I'm just watching the presentation. It's not clear to me whether the boats are going to be with the bow point to the land, or are they parallel to the seawall? It's not clear from what's being presented. That'd be helpful. That's my only question.
Does the applicant want to answer that? It appears to me they're going to be perpendicular, but I'll let.
So the bow of the boat will be facing into the seawall. Maybe to follow up to your last question, it just dawned on me why we don't go parallel to the seawall also. If you're trying to dock your boat and the two neighbors to the north and south rebuild their dock and have to go out that far, it may impede on their riparian rights also.
Thank you. Any other comments by the public? If not, closing remarks by planning and development staff.
We're good.
Closing remarks by the applicant.
Good afternoon again. I'll be concise. As you know, this is a process. This is the first step in the process. Clearwater has its own requirements. One of those requirements, as I read to you, is that the dock, the length not impact the marine life or the seagrasses or the seabed. And that is one of the reasons why you start to see these applications that relate to benthic surveys and seagrasses. This is consistent with all of the applications I've had in this regard over the last 5 years. This is probably the third or fourth dock application I've had before you this year. And I do have several that are 80 feet plus on island estates. that have been approved with varying degrees of opposition. This is the only one I've had with no opposition, to be honest. I've got a dock case tomorrow night in Bel Air Beach with a ton of opposition. So typically, these docks, whether it's the new standards or the things that are being required as it relates to county and FDP approval, are pushing the docks out further, and I think probably engendering more opposition. I think in this case, it's great that we don't have that. We have the neighbor that's being impacted by that southern setback signing off and approving it. And again, as it relates to the quasi-judicial nature of this hearing and the consideration of the competent substantial evidence, you've had indisputed testimony from the planning staff and the harbor master through their staff report. You've also had the testimony of Mr. Carrier, who you've relied upon in many other cases over the years for his expertise, and who does this on a daily basis as it relates to permitting and design. You've had no contrary evidence to consider as it relates to competent substantial evidence that's been presented as evidence before the board. So with that, just encourage you to approve the staff recommendation of approval with the additional condition of approval that there be no tie poles extending seaward of the roof structure. Thank you.
Thank you. Okay, we're closing the public hearing at this point. Discussion and vote by the board.
We can't request anything in Pinellas County, can we, Jay?
I'm sorry?
We can't request anything for the next levels with Pinellas County, right?
No. No. The question was, can the board require anything, request anything from Pinellas County relative to the application?
Thank you, I was having a hard time hearing
Sorry.
it.
I do know I had a neighbor that her job was to put on a mask and fence. She worked for Pinellas County and go out and check before the permits were issued. This was years ago. So they check, they go out and check the applicants. What percentage, I don't know.
Sheet. I'll make a motion, but I don't have my sheet with me.
Oh, sorry.
There you go.
Level 2, I move to approve case number FLD 2024-07017 based on the evidence and testimony presented in the application, the staff report, and at today's hearing, and hereby adopt the findings of fact and conclusions of law stated in the staff report with conditions of approval as listed.
Does your motion include the condition set forth by staff later concerning the
Well,
pilings?
with the additional condition for no tide poles beyond the,
Seaward of the roof structure. Also, did we do ex parte?
We did.
Okay.
I'll second that motion.
All right, you have a motion and a second.
All those, any more discussion? All those in favor?
Aye.
Aye. All those opposed?
No.
All right, you have one opposition, so the motion would pass 4-1.
No,
I
it's
think you
two.
had two.
Is it 2?
3-2.
Oh, I thought there was only one.
One procedural point about, so the effect of the 3-2 is that it comes right back to you next month.
That's
You're
correct.
gonna have the exact same presentation a month from now, with the same evidence.
That's correct. A 3-2 vote
And
pushes
if
the
you wanna do that, If you
application.
wanna make us do that, we'll do it, but it seems like a waste, to be honest.
It may seem like a waste of time, but that's what the code says, so that's what we're going to do.
Yeah, I understand.
We have a 3-2 vote. Do I understand that correctly? All right, so I'd ask for staff to place this on the agenda for next month's meeting. And we'll move on from here.
May I ask if what else we can provide for direction, maybe from the members that needed more information, what other information?
I wouldn't presume to speak for them. It's not part of the code to have a secondary.
Just so I could get, I want to make sure it's a good use of your time.
Sure,
What you need.
I would suggest that maybe staff gets more involved in this with you in terms of, we weren't clear on tie poles. We brought that up. I didn't want to.
All right, I'm gonna shut this down. We're not doing this today. All right?
Thank you, sir.
I just think
We'll
there's
come back next
options
month.
that exist versus setting a precedent for the whole
Listen,
Island
we're gonna
Estates
take one
corridor.
application at a time,
Thank you.
period. Mr. Chair, if you'd move on to the next application, please.
All right. Okay, next application. Case number FLD 2023-05011, 685 and 689 Bay Esplanade. Owners, Peter Pan Developments LLC and Peter Pan Division. Applicant, Hush Gove, Northside Engineering. Location, southeast corner of Bay Esplanade and Somerset Street. Request is for flexible development approval to construct a 9-unit resort attached dwelling use in the tourist zoning district, Old Florida Character District of Beach by Design for properties located at 685 and 689 Bay Esplanade. The building will not exceed 50 feet for the first 60 linear feet south of Somerset Street and will not exceed a maximum height of 65 feet elsewhere, and 14 parking spaces are proposed. Request is for flexibility for height, as per the Community Development Code, Section 2-803, Associations Clearwater Neighborhood Coalition, Board of County Commissioners, Pinellas County School Board. Planner is Melissa Huck Baker, and we will start with presentation by planning staff.
Mr. Chair, before we get there, let's request ex parte communications as well as request for party status, please.
Okay. Thank you. All right. Is anyone requesting party status for this item? Seeing no one, we'll move on. And the board has previously qualified city staff who will testify as experts in the area of professional training and education. The list of city experts and their resumes in the handbook and the podium.
I'll stop, Mr. Chair. We're just looking for any board member who has ex parte
sorry.
communications to disclose. No, you're fine.
Does anybody,
Anybody? Okay.
ex parte status? Okay.
All right, so then it'll be appropriate to hear from the applicant first, or excuse me, planning and development staff first. 10 minutes.
Mr. Chair, at this time, I would ask that the board accept Ms. Melissa Hawk Baker as an expert witness in general planning, zoning, redevelopment planning, land development code, land development code amendments, special area plans and overlay districts, site plan review, landscape architecture, historic preservation, comprehensive sign programs, and all other matters she is about to testify hereon.
I move to approve Melissa Hawk Baker as an expert in this field.
Second.
All those in favor?
Aye.
Opposed?
Good afternoon, Melissa Hauck Baker, Planning and Development. The case before you is FLD 2023-05011. It is for the properties 685 and 689 Bay Esplanade. The existing structures that you see on the slide, the project would include the demolition of the existing 15-unit attached dwellings, which date to and were constructed approximately 1951. The proposed project is on the east side of Bay Esplanade and on the south side of Somerset Street at that intersection, as well as along the waterway to the east of the Mandalay Channel. The code is our community development code. This area is included in a special plan, which is Beach by Design. Beach by Design supersedes the community development code. So this property is in the Old Florida Character District, and the Old Florida Character District actually supersedes the Beach by Design guidelines and the CDC. So first, staff looks at Beach by Design, and we look at the Old Florida Character District. Anything that isn't included there reverts back to the regular Community Development Code. And this is a resort-attached dwelling that's proposed, which all uses in the tourist district are either a level 1 application or a level 2 application. This use is permitted as a level 1 use. The height limitation is 35 feet to 50 feet. The limitation under, as a level 2, a resort-attached dwelling can go from 35 feet to 100 feet. However, Beach by Design limits the height as 50 feet maximum from 60 feet, 60 linear feet from Somerset Street. The first 60 feet, you can go up to only 50 feet in height. After that point, the remainder can go up to 65 feet. So Beach by Design does place a limit of 65 feet as the maximum height, and the project complies with that. The proposed setbacks are going to be 15 feet along the west and the north, so that would be along Bay Esplanade and Somerset Street. 15 feet where 15 feet is required. The remaining 2 property lines, the east and the south, are going to feature a 10-foot setback, which is also required. The step backs. So Beach by Design talks about when you go to a certain height and elevation, the building must step back. Along the north side, Somerset Street, the required step back is 6 feet, and the project is proposing a 9-foot step back, so it more than complies with the requirement. Along the west side, there is a requirement for a 12-foot step back, and the proposed project includes 14 feet step back. There are also landscaping requirements where the project, or the code, I should say, along the west and the north sides. Beach by Design, the Old Florida Character District, requires a 10-foot minimum landscaping buffer where the project is proposing 15. And along the east and the south property lines, they're proposing a 10-foot landscaping area where Old Florida requires a 0-foot buffer. So they are going above and beyond what is required. There are 14 spaces that would be required for the proposed 9 units, and the project includes 14 spaces that will be under the building. The main access vehicular is off of Somerset Street. There are several slides here of the elevations which help to depict the transition from the Somerset Street. So the east elevation, which you see right now, on the right-hand side is where Somerset Street is located. And you can see where the building, for the first 60 linear feet from that point, is limited to a maximum height of 50 feet, and that is what the project complies. The remainder of the building is allowed to then extend up to 65 feet in height, and it complies with that. This elevation is the north elevation, so this would be looking along Somerset Street, looking south. And you'll be able to see the step back. So there's the step back required along Bay Esplanade of 12 feet, where the project is proposing 14. And likewise, this is the elevation from Bay Esplanade, where not only can you see the height limitation for the first 60 linear feet from Somerset Street, you can also see the required step back, or the proposed step back, I should say, which is 9 feet, where 6 feet is required. The project is compliant with Beach by Design, the Old Florida Character District, the remaining of the design guidelines as well as the community development code, and I'm happy to answer any questions.
Is there a
Yes.
difference between a resort and hotel, or are they,
So a resort attached dwelling is a dwelling that can be rented for any time period. An attached dwelling is limited to a maximum, or I should say a minimum of a 30-day. It has to be minimum of a monthly rental
In our residential districts.
in the residential
Right.
districts, correct?
If I can add to that also, so the difference between a resort attached dwelling versus overnight accommodations or a hotel use is the density, because it's still limited by the residential density, which is
Okay.
fewer units than a rooms per acre calculation for overnight accommodations.
What is the deviation that is being requested from which code, if I may?
Sure. So the reason that this is a level 2 application is simply because of the height. If the height was limited to a maximum of 50 feet for the entire structure, that you wouldn't have even seen this. This would have been handled as a level 1. The Development Review Committee would have reviewed it. But because they are proposing to go up to the 65 feet, which is contemplated by the code as a level 2, if this wasn't in Old Florida, they could go up to 100 feet. But because it's in the Old Florida Character District, they're limited to a maximum of the 65 feet.
Well, you said they're at 65 feet.
Correct.
So what's the deviation?
It's any use in the tourist district, it's either a level 1 application or a level 2 application. The reason this is a level 2 application is because as a level 1, for a resort attached dwelling, the height range is 35 feet to 50 feet. As a level 2, a resort attached dwelling height is 35 feet to a maximum of 100 feet.
Okay. And you stated in your report that this met the character of the neighborhood, and therefore it's on the consent agenda for approval. But I live 7 doors up the street, and I haven't seen a building that met this level of height in this immediate core along Somerset, et cetera. So I'm just wondering, you put it on the consent agenda, but it doesn't seem like it meets the character of the neighborhood.
Let me clarify real quick for that, because items are on the consent agenda. When the planning and zoning staff recommends approval, the applicant is in agreement with any proposed conditions, and no written objections to the case have been received to date. That's how an item gets on the consent agenda. All right? Just want to make that clear.
Well, actually, even if we get written objections now, it still stays on consent pursuant to the new rules.
Fair enough.
isn't there a hotel nearby? There's a hotel nearby that, right?
Fairfield.
I'm sorry?
The Fairfield Inn? And do you know how many stories that is?
Not off the top of my head, no. But I know that project went through as a level 1 project. That
Okay.
didn't come to the board. But I think it's definitely a taller building than this one, but it's
Right.
also because
That's what
it's
I'm
a
asking.
different
So,
use.
so had this been 50 feet, it still would have come to this board just as a level 1?
Level 1 uses go to the Development Review Committee. They do not come to the board.
One question I'm confused about, and that's why I pulled it off, is I thought that it had to meet, under the old Florida, it had to meet the character of the neighborhood, the height, size, and all that. Isn't that part of the considerations?
That is true. The project is being designed to meet what the anticipation is of the fulfilled ultimate completion of design, Beach by Design. You know, if every property were to redevelop, this is what is contemplated.
It's like across the street, they just built the 3-story Airbnb units, correct?
Correct.
I mean, but currently, this property right now is being used for rentals as it is.
Correct.
So it's not changing the look of the neighborhood, it's just, to me, with what we just went through and the devastation on the beach, I applaud this myself personally, because it's up elevated, the parking's underneath. I think this will stand through things like we just experienced. So I think that the character neighborhood just got enlightened.
Well, consider this too also, is that if you look at what's there now compared to what's being proposed, it's gonna be less units. You're going from 15 to 9.
Correct.
It's going to be what? I'm sorry.
It's
Yeah.
going from 15 units for the current building to 9. It's going down.
And also, the existing development is considered non-conforming. Number one, the parking is technically within the public right-of-way area. It backs out into the street, which is not allowed for a multi-unit property, as well as the FEMA flood hazard level. And there are residential units on the first floor. When it floods, they lose everything, and the proposed building will comply with FEMA requirements.
Relative to your statement, then, how many additional bedrooms are being added from the current state of 15 units to this state where you have, what, 45 bedrooms now instead of 15?
So the code doesn't break out bedrooms.
No, I understand. I was responding to the attorney's comment relative to the units. I didn't know why that was relevant, that's why. But I'm still confused about the 3 different codes and how they applied, and
Yes.
that's why I asked the question,
Right.
because I live the street. So I'm anticipating what's going to happen next in my neighborhood. That's the purpose of my
Yep.
asking the question.
The code is a redevelopment code. It builds into it levels of flexibility that may be requested. So the first option is when the zoning district provides minimum standard. Minimum standard goes directly to a building permit if the project complies with all of the items in the code. The next option is level 1, and that goes to the development review committee. And then ultimately, the maximum amount of flexibility that may be requested is typically under the level 2 applications, which must come before you.
Thank you.
So beach by design, ultimately.
So it's like a combination. You have to keep floating back and forth between them. You literally need to have both of them open in front of you. And it's
Beach by
It's-
design basically lays out like, all right, here's the range of heights you can have, right? But just because that's your range of height doesn't mean you automatically get it. Then you have to turn to the community development code, which is, okay, well, if you want this height, then this might be a flexibility level approval, this might be just a permitted level of height on its own. So like there's different levels there. So the beach by design is kind of more of your guiding principle, and then you turn to the code to go into the specifics.
anything else? Okay, thank you.
No further questions? Thank you. Presentation by the applicant.
Good afternoon, Hush Kovahi, Northside Engineering. Thank you for being here today and listening to us. Wanted to state that we have carefully designed this project. We have worked very, very hard on it, and we have been interacting with your staff for many, many months to get it to this point. So the drawing before you wasn't just a sketch on the paper and, sent to the city. Your staff is extremely knowledgeable. They are very, very advanced in what they do and their determination and interpretation of the code. So early on, we had, different sort of a design, but working with your staff for months, we got it to a point as it is before you. And as Melissa stated, in all cases, this site meets and exceeds your code. Now, as you know, there's basically a code and there's an overlay. So your code, beach by design, basically says you can go up to 100 feet, and there are other criteria. But the All Florida District basically restricts it. It puts another overlay on that said, okay, this particular area is considered All Florida, while beach by design may have other districts, like South Beach and all the other places, they may have other overlays. So that Old Florida Character District basically restricts it in many cases, including the height. So generally, a height, as Melissa stated, you can go up to 100 feet. As you see, many hotels go up to 100 feet, like a Hyatt and some of the other hotels, but they don't have that overlay district to reduce and control the height. And here, they do because they want it to be more associated with the residential units that are near you. So in short, I just wanted to state that staff made a wonderful presentation. Existing building does not definitely meet FEMA regulations. And of course, this past couple of weeks been sort of devastating to all the beaches. And we've experienced, the properties and the loss. But this design will meet FEMA regulations. Actually, over and above FEMA, there is another regulation that the county had just come up with. So if FEMA allows you to go to, let's say, elevation 11, the county has said that it needs to go up to elevation 13.7 for the first living floor, and that's what we have done. So, anyhow, I'm glad to answer any questions.
Questions by staff or by the board? Seeing none? Cross-examination of witnesses by the planning and development staff.
No, thank you.
Cross-examination of witnesses by the applicant.
None, thank you.
There were no party stats. Comments by the public.
Again, Bill Johnson, 2694 Redford Court. I'd like to compliment Mr. Hupp for his questions because it gets at the intent of the code, which is how does this fit with the surrounding area. The original code started out with the 65 feet in the old Florida district, and the council, which I was on the council at the time, said we got that one building on the other end of Somerset that's very tall, and it was towering over the residential area. So the code was modified in the old Florida district to have these steps. The other area of the old Florida district, old Florida Character District, was intended to have an old Florida character. I don't know how that has been evaluated by the staff in this particular instance, but it seems like it's just a typical new building here. But I just wanted to compliment you. The general acceptance criteria is required to be met for going above a level 1, and that should have substantial competent evidence being submitted by the applicant according to your code. And I haven't done the detailed look at that, but thank you for at least wrestling with this. I believe that's your principal purpose of this board, to evaluate and look at those issues on these exceptions for the level 2. Thank you very much for doing that.
All right, thank you for your comments. Closing remarks by the planning and development staff.
Yeah, I just wanted to make one last comment about the character district and how it relates to height. I remember the old Florida Character District specifically says that heights within the range that this project has is permitted in that character district. So I'm not sure how we can say necessarily that it doesn't meet the character based on height if the district specifically says heights within that parameters is okay. That's all I wanted to say.
We have no party status. Closing remarks by the applicant. Yes.
I'm Matt Temprin, T-E-M-P-R-I-N-E, 711 Bay Esplanade. So I'm about 3 or 4 houses from this project right here. I do disagree that it doesn't change anything or it improves it, like you're saying about the old Florida. You take a look at that picture. I came to visit 20-some years ago in South Beach, right? I don't recognize the place. So if that's the direction that you want to go, that's what you'll have at the end. You only have one shot at Old Florida. This is it, right now. It's going to change, we understand that, but it's not the same thing. When you live that close to that, the noise explodes at 5 o'clock on Friday. So when you think everything is the same, it's not. It is very hard to live next to that. So it ends on Sunday at whatever time. If you want to pull up that picture there one more time about where it's landing, as Mr. Huppert said, there's a big behemoth project that's being built right now. This is catty corner to it, and that same developer owns the property in between those two on the water. Same thing's going to happen in whatever months to put more townhomes in or whatever. You're going to have this huge corner of behemoth buildings, and they're all set up for party buildings. With 9 units, 14 spots, that's 1.4 parking spots. Party houses have a minimum of 4 spots that you need. I have counted as high as 25 cars in front of the one building that's right there for one rental. They're on the parking lot, they're everywhere, they come into the residential district, so it does change. It changes a lot of what we're looking at right now. So it's not just a, well, it's a beautiful building, and granted it is, I'll take that away from you right there, but it's not old Florida. Like I said, if you want to bring South Beach up to here, right, that's exactly what you're going to get. Thank you.
Thank you for your comments. Closing remarks by the applicant? No comment. No comments from the applicant. Closing remarks? This closes the public hearing for this item. Discussion by the board.
The point that he just made is the one that I see every day living on the beach is they build these massive 5, 6 bedroom townhouses, condos, which is what this is set up for. They park at 1.5, which is what the code allows. And so there's no real argument for that, but there's going to be an extra 25 cars and the party status going along the street, and it's going to convey north. And I think the code and everything that's getting permitted on the beach has to look at the number of bedrooms and the amount of parking spaces. And they haven't done it. It meets the code. It meets the criteria. And I think it's going to be a problem that's going to proliferate. These people are paying $800,000 per unit to create these VRBOs. And every one that's been built, I look at them every day and see the number of cars there. And we're going to hear the parking garage will accept the off-site parking, from these people, which is not the case. And it's going to be South Beach, and it's already started, and we can't stop it. And I'm just perplexed as to the density that this project has. They're 4 and 5 bedroom, 3,500 to 4,500 square foot units that are going to be VRBOs, and they get $1,500 a night, and that's what they're being built for. And it's right next to the quaint residential neighborhood that's going away. And I think it's relevant for the council to know this.
I think part of when you talk about the cars and the traffic and things like that, I think that's going to be a police, they need to address that. If it's more than what's supposed to be allowed, it should be addressed like that. That's against the use of the building. I think there's a lot of other things going on in our city, even on the beach and different places where people park cars in the grass when they shouldn't. So there's all kinds of things that the police need, or code enforcement needs to take care of. But the fact that it meets the code of 1.5 cars per unit, I think that's what we have to base our opinion on.
Correct.
And as far as the living conditions of, You know, it's great that everybody, you know, sometimes we talk about the view. We can't, you can't take away somebody's view. Well, yes, you can. You don't buy a view. All right, well, same thing. It's great that you can live on the water. I lived on Island Estates and I had beautiful views. They built a condo building in front of me. I had to move because I didn't want to look at that condo building. But at the same time, that's not, I couldn't buy that. And the same thing goes here. I don't want to see, it's not old Florida anymore, I'm sorry to say. It has changed. And from what I just heard, Carlwell might not reopen because it's been so destroyed. But so it's, you know, it's great that everybody has a lot of money and can afford to live there, but that doesn't mean we have to stand in the way of progression no matter what it is. I mean, I think VRBOs are crazy. I think Airbnbs are crazy. I like hotels, but that's not my choice. My choice is what I want to do. But in regards to this, going back to what we have to vote on, if it meets the criteria of what it is, that's what we're supposed to be voting on. As much as when I sat with the attorney here, he told me that's what I have to do, is I have to look at the laws and not what I feel. So based on that, that's my 2 cents.
Any more discussion by the board? Would anyone care to make a motion?
Yeah, I'll make the motion, I just have to read it. I move to approve, let's see here. I move to approve case number FLD 2023-05011. Let's see. Where are we at? Okay. Based on the evidence and testimony presented in the application, the staff report, today's hearing, and hereby adopt the findings and the facts and conclusions of the law stated in the staff report with conditions of approval as listed.
Do I have a second?
Second.
Got a motion, we have a second. All those in favor?
Aye.
Aye. All those not in favor? Motion carries.
All right, Mr. Chair, now it would be appropriate to read your level 3 procedures and move on to the last application for today.
All right. All level 3 cases, such as a plan amendment, rezoning, or development agreement, are considered legislative hearings. The Community Development Board reviews the application, the staff reports, correspondences, and all evidence presented today and makes a recommendation to the City Council. For level 3 applications, the City Council makes the final decision. The procedure for all level 3 cases is as follows. Presentation by planning staff, 10 minutes. Presentation by applicant, 10 minutes. Comments by the public. Closing remarks by the planning and development staff. Closing remarks by the applicant, followed by closing of the public hearing and discussion by the vote by the board. Our first level 3 case today is the first one was continued to next month, right?
Was that the one that was continued?
So this is-
F3 is, yeah.
So this will be case number TA 2024-08003, murals and downtown window signage. Applicant is the City of Clearwater Planning and Development Department. Request amendments to Community Development Code to clarify definitions for artwork and murals and to modify window signage standards in downtown. Associations, Clearwater Neighborhood Coalition, Board of County Commissioners, Pinellas County School Board. Assigned planner, Laura Matsky.
Good afternoon, Lauren Matsky, Planning and Development. So as covered in the staff report, staff presented information to City Council at their July 29th work session. regarding signage options in the downtown district, because the downtown district has its own specific sign code. Following that discussion, there was agreement by the city council to increase the percent allowed for window signs from 10% to 20%. I don't have slides for this, sorry. From 10% to 25%. Currently, the rest of the city is allowed up to 25% of their window area to be window signage, and city council wanted this to be applicable also for downtown. Downtown has other types of signage that are allowed that are not otherwise contemplated citywide. So this ordinance also includes modifications to the definitions for artwork and murals to provide better distinction regarding what would be treated as signage, what is commercial speech, versus what is just part of the artwork if integrated into a mural. So we worked with legal on those changes to ensure that we were good with any First Amendment issues as well. That will get staff out of the my item. That will get staff out of the need to kind of, you know, estimate or determine what's commercial versus not. It's more spelled out there. And clearly murals are part of a vibrant community and is something that we want to continue to encourage. Lastly, the only other thing I want to point out is I did correct a typo. I caught a typo after I sent y'all the ordinance. In the definition for artwork, I had accidentally repeated the same phrase twice, so I will have that corrected before it goes to City Council. With that, I can answer any questions. This is a very limited scope ordinance for y'all for a change.
Questions by the board?
Thank you.
So it appears we have no questions. And then presentation by the applicant, that's the same? Want the same. Comments by the public?
That's me. Bill Johnson, 2694 Redford Court West. I have one overriding concern, and it's just simply the diagrams. It says the diagrams are not drawn to scale. If we're going to put this in the code, I think the diagram should be drawn to scale so that it reflects what's actually there. The other comment I have is a general comment that we have views that look like this in Clearwater where there's not enough diversity in the signage, and we need to be allowing more diversity in the signage than we have currently. And I use as an example the city of Portsmouth, New Hampshire, where you have a variety of signage, a variety of the frontages of the buildings, and some of this could be done by using the standards that were presented to the city back in 2009 in the Street Sense report, which has not been chosen to be fully implemented. It would allow a slightly larger amount of signage in downtown, would allow 2 square feet for each frontage foot rather than the current code, which is 1 square foot. And so I think there's an opportunity to create more vibrancy in the downtown area by being more, less conformist, if you will. So that's a comment, but please, let's do the drawings to scale. Thank you.
Thank you. Closing remarks by planning and development staff.
I'd just like to add that there are a wide variety of signs allowed in the downtown sign code. And some of these examples are shown in the graphics that are provided. It's designed to be more hierarchical in nature, so more design-based. Unfortunately, sometimes our business owners don't take advantage of all the types of signage that they are allowed. So that's certainly something that we would encourage, and is something that we covered with City Council in that presentation, because that was one of the reasons why the window signage was initially limited to 10%, to kind of diversify the types of signage used in downtown, including the awning signs, the projecting signs, things on the canopy, et cetera. So, and then regarding the graphics, I'll just say they were originally created by an architect who worked in our planning and development department at the time. I don't have those same skills, so we made minor modifications to better reflect the one change. But if additional changes were warranted, I'd need help. So, thank you.
Can I ask her a question or no? 'Cause time's over.
Of course, just speak up into the mic.
I'm sorry.
Thank
So
you.
what I wanted to ask is, so does this change, like you see those, I guess, tobacco stores that the whole glass is all covered with signage, I guess, is that what we're allowing now, or?
No, and that was part of the conversation at City Council, so I'd always encourage people to watch that, because there was some code enforcement done in downtown with certain windows that were more covered
Right,
than what
okay.
was allowed. And so that was kind of the impetus
But
for
we are
the
going from
conversation.
10% to 25 now, you said?
This
or-
would go 25% total, but
Oh, okay.
I want to just find the statement. Sorry, I have it all printed on different sides. But it would not be allowed to cover
Sure.
an entire sign. It would still be limited, and then to the point, there's still an overall maximum amount of signage, so.
All right.
But yeah, with downtown, one of the requirements for new construction or major renovations is that windows be clear, open, storefront type windows.
Okay.
So,
Yeah,
Thank
it looks
you.
like it's going from 10 to 25%, but you still have an item in there that says a maximum of 50 square feet.
yes.
Okay.
Anything, sorry.
Closing remarks by the applicant.
I have no other comments. Thank you very much for your time.
Okay. This closes the public hearing portion of this item. Discussion and vote by the board.
I'll just throw 2 cents in there, since most of the people that downtown are personal friends, businesses, clients, and so on and so forth. I think that everything, Bill, what you said is true. We need diversity in signage. I'll be honest with you, a lot of people, if you said there are laws that say they can do certain things, evidently they can't find them, because usually it's somebody saying, no, we can't do this, no, we can't do that. And so I'm glad to see this change. I think it's needed. I think we need to continue to give them every opportunity to succeed, so.
I think the signage usage is based on who owns the building. So like you were showing that picture of Scientology Row, that's the church that's dictated what signs they want to put up. And we can't make them put up something else, so, even though we give them the option.
I was going the opposite side of things.
Oh.
It's, if people want to try to put a sign up and it says, no, you can't do this, no, you can't do that. I've been through it. There are a lot of sign companies that do not like to work in Clearwater because of the restrictions. So this is, that's a different animal. We're talking windows and murals and stuff here, so, but this is a good start.
I'll just make a comment. It's a good time to change the code, because half the signs I've seen have blown down in the past couple of weeks. A lot of sign applications coming up. All right. Let's see. Any further discussion?
I move to recommend approval of case TA 2024-08003, based upon the finding of fact, conclusions of law, and the staff report.
Second.
All those in favor?
Aye.
Aye. All those against? Motion carries. there any other level?
Director's items?
Yeah.
That's it for your agenda?
Yeah, there's no director items from me.
I'd like to bring something up if I could. This, it's a personal thing. In fact, I've talked to the attorney about this before I got on the board. And I know that in the past, the board has always not just did the Pledge of Allegiance, but also did prayer. And I know City Council does prayer. And I'm a firm believer in prayer. So I know that this board used to do the prayer, and then it went away from it. And I'll be honest with you, there was a City Council person that asked me to put this on back on the back in the board. So I'd like to get everybody's consensus or what their thoughts are about starting our meeting with a prayer also.
What kind of prayer?
And again, as much as I'm in one way, it doesn't mean, just like City Council does, it's a prayer of
Do they say the same-
diversity, so to say.
They say the same prayer every time?
No, it's always different.
I have a question. So, I don't know if you're mentioning the council in the process. So the council, what they do is they do invite individuals from different denominations to offer the prayer. And so my question is this going to be given from the board members themselves, or is there an expectation of staff to go out to the community, which is not very easy, to make sure that it's open to all denominations and that there is a process of making sure that everybody's represented?
I can speak from a historic standpoint. The chairman used to ask the members if they wanted to have a prayer. And then they could, if you volunteered to do that, you could do your own prayer, or you could read the one that he provided in the staff minutes. You know, it's pretty, like you say, non-denominational.
I did speak to council or a board member about that earlier, and I know that this won't be a galloping shock to him, but I continue to recommend against prayer. Not because I don't believe in prayer, I deeply do. Lord knows I need them as much as you or anybody else does. From a legal perspective, frankly, it creates more issues than it solves. There are First Amendment issues related to it. There are equal protection issues related to it. And in my legal opinion, those are not issues that I believe this board should be trifling with, given the breadth and scope of what you're already charged with doing.
Well,
And I would further add, you guys are less than a full board today. I really think that you should have your full board here, at least your chair and vice chair, before you go down. And if you wish to proceed on it, I would like for you to receive a legal memorandum from me outlining the contours of how this can be done lawfully.
That makes sense.
And I've been doing this a long time, and a lot of jurisdictions, city councils, boards, including this one, and I've had this board for a long time, do say prayers, denominational, non-denominational. Many places invite clergy or others to do it. It generates a lot of case law. I'm always happy to take your money. I just don't know that this is the best expenditure of it in the event that we tiptoe outside those boundaries. That's my point. But I do believe that you should wait for your full board to be here to have the full discussion on it. I think that's best.
Just to understand the process, is that just a simple vote of the?
Yeah, I would put it back
board?
into your script or rules of procedure. It's an easy change to make. It is a less easy change to execute lawfully.
So when I was on the board 8 years ago, it was on. Can you tell us why it was dropped?
For the First Amendment and due process issues that attend it.
Can I speak to that? I mean, I've been told, and I don't know this, but the chairman of the board at the time is the one who pulled it. He's the one that, I don't even know his name.
Oh, boy, yeah.
But he was a Quaker, and it was his choice to pull it.
I think I've had 40 members of this board that kind of had it. I couldn't tell you the religious affiliation of a single one of them, so I don't know the answer to that question.
Again, I agree with you.
Yeah.
All 7 should be here.
Yeah. My memory isn't good enough to say why it was
Table
extinguished.
that item for next month.
Yeah,
All right.
I think that's a good idea.
Yeah, wait till we have a full house for that one.
I'm sorry?
Wait till we have a full house to
Yeah.
to discuss that one.
I have one last question. We have an extra camera in the background. What is,
That's because we don't have any internet service
Oh, okay.
inside chamber, so they're recording it so it can be uploaded
all
later.
right,
Oh,
thank you.
there you go.
One of the storm.
All right, no further items. This board is adjourned at 2:58. Thank you for attending.
Thank you.